Mr. McLeod,
Contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt court taken into custody.
Really? That's it.
This hearing turns into complete chaos from the very first minute. Mr. McLeod is facing serious charges for assaulting a police officer, but instead of mounting a real defense, he pulls out the classic sovereign citizen playbook. He interrupts, shouts pseudo-legal jargon, and insists the court has zero jurisdiction over him. But this judge isn't having any of it. Watch how quickly the defendant's confidence crumbles. Under actual legal reality, ending with a direct trip to a jail cell. Make sure to hit that like button, subscribe to the channel, and let's get right into the breakdown.
Do you understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or $100 to $500 term. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Notice just how composed the judge stays throughout this exchange. Even with constant interruptions and bogus legal theories, he gives McLeod multiple opportunities to protect his own rights. It takes incredible patience to deal with someone deliberately pretending not to understand basic statutory law. Drop a comment below. Do you think this defendant actually believes his own arguments, or is this just a desperate stall tactic?
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble.
Okay.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
I don't understand the nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power, and the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So, Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face for 3 years in prison and or $1,000 fine?
One second.
I can see why his attorney would, Drew. Oh, shit.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing.
That accidental hot mic from the prosecutor's office perfectly captured what everyone in the room was thinking. It's hard to blame her. The absurdity here is off the charts. And it's a miracle the judge kept a straight face, looking at McLeod frantically shuffling through his paperwork. It's obvious why his previous attorney walked away. Sovereign citizens love to act like they've uncovered a secret legal cheat code that will force a judge to dismiss their case on the spot. In reality, the entire courtroom knows how this ends. Watching someone try to navigate a high-stakes legal system with made-up rules is both wild and exhausting. Let's jump back in and see how the judge handles the rest of this.
Mr. McLeod, do you understand the maximum penalty that you could face?
One second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
doesn't
jurisdiction.
exist under the Constitution.
Your objection's noted. Okay. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on.
You can pinpoint the exact moment the judge decides he's done playing along. Without raising his voice or losing composure, he dismantles McLeod's entire routine with pure legal authority, calling out his inability to grasp basic statutory proceedings. Isn't just harsh, it's a clinical, on-the-record warning that the clown show is officially over.
I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod, stop.
the court can be
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
these
McLeod,
statutes.
I have other matters. Mr. McLeod,
Involved agency. What's that?
you know, I understand you want to object to things and you're going to be allowed to object to things. Okay.
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
No,
I
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying enough to where I can comprehend it, as you say.
you don't comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong and you can appeal.
There's no such thing as a statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question or I'm going to hold you summarily in contempt and the court officer will bring you to a jail cell and we'll talk about it tomorrow. You understand that?
So.
Mr. McLeod,
Contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court, taken into custody.
Really? That's it. Protecting my rights is what you said last time, sorry. This isn't true. You guys are following.
Follow unconstitutional
You're
orders.
following law orders, it's not constitutional at all.
Mr. McLeod's in contempt, he's sentenced to 1 day in jail. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is
notice.
about the Constitution. I did nothing wrong except to question and exercise my rights.
Trying to play courtroom chess without knowing. The rules is a guaranteed way to land. Yourself in custody. Under the Sixth Amendment, every defendant has the right to legal counsel. Yet McLeod chose to gamble 3 years of his freedom on debunked sovereign citizen scripts. The courts have rejected these exact jurisdictional arguments since the 1990s. There are no magic words that bypass state statutes. When facing a felony assault charge, wasting the court's time doesn't get you off the hook. It earns you a contempt charge. Try to navigate an extra night in a holding cell and puts you at risk of losing core civil liberties. That wraps up today's breakdown. What's your take on McLeod's defense strategy? Let me know in the comments below. If you enjoyed the video, leave a like, hit subscribe for more legal breakdowns, and I'll catch you in the next one.